Hi, good afternoon. Welcome, and thank you for joining us for our webinar on the new Title IX, What You Need to Know Now. So I'm Emily Tulloch, and I'm joined by my colleagues and fellow Title IX Insights bloggers, Amy Dickerson and Jackie Wernz.
Hi, everyone. This is Amy Dickerson.
Hi, this is Jackie Wernz.
So just before we get started, a little bit of housekeeping. We imagine that you guys all have a ton of questions, and we probably aren't going to be able to get to them in the limited amount of time we have today, but please do submit them through our Q&A function on Zoom. We're going to plan on addressing all of your questions on our blog, which is title9insights.com. So make sure to hop over there, subscribe, and you'll receive our alerts when new content is posted. And we'll also be providing a lot more insights on Title IX in the coming weeks and are going to be announcing some future webinars as well.
So we're excited to welcome representatives from such a wide variety of institutions for this conversation today, including representatives from public and private K-12 schools and community colleges, and universities from across Illinois and across the country. For any of you who don't know, our firm, Franczek PC, is one of the premier education, labor, and employment boutiques in the country. Because of our clearly defined practice areas, we are able to offer unparalleled service to our educational institutions in Illinois and beyond. As a reminder, all of our marketing materials, including webinars and blogs, are not replacements for legal advice. If we can ever help you with any specific questions, please let us know. And also, just so that you're aware, we have tried our best to fit everything into 30 minutes today, but my prediction is that we're probably going to go maybe 5 or so minutes over. So if for some reason you aren't able to stick around until the end, please just look for an email from us that will include a link to the recording as well as the materials, and you can catch up on it on your own time.
Great. So let's jump in and talk about Title IX. As you all know, on Wednesday, May 6, 2020, the U.S. Department of Education, headed by Secretary Betsy DeVos, issued the long-awaited Title IX regulations. The proposed rule was issued in November 2018, and the final rule is the first time since the regulations were first issued in 1975 that they have been amended. So we have been talking a lot amongst ourselves for months about when the rules were going to come out, with whispering since January of this year that they were imminent. So now we can see from the 2,082 pages of the current draft final rule that the likely reason why it took so long, the vast majority of the pages include discussion about the nearly 125,000 comments that the department received to the proposed rule. So as Jackie said, we have 30 short minutes with you today, and we obviously are not going to get to everything that you will need to know about these regulations, and we'll probably only scratch the surface, but our goal is to provide you what you need to know to begin moving your institution forward toward compliance.
So because we only have 30 minutes with you today, we wanted to just provide a quick roadmap of what you can expect us to cover. So first, we're going to start out with some really high-level insights, and then next we're going to dig into some of the specific changes in the rule that you should be aware of. And then we're going to end with some practical checklists that you can use to move your institution toward compliance with the new rules.
So to begin with, let's talk about the 30,000-foot view, or the big picture. One big picture takeaway is that if you had never heard of the Gebser and Davis Supreme Court decisions before now, you are going to learn about them very quickly and very thoroughly, because really what has happened here is that OCR has taken the standards from those cases and folded them in and made them and altered them, but made them a part of their process. And the basic idea is that the Gebser and Davis decisions are two Supreme Court decisions that set the standards for money damages in Title IX lawsuits. And generally speaking, the standards are much higher there than they were under the standards OCR has been using since 2011. So there really is some truth to the claims of those who oppose this regulation that it is going to be harder to find a school liable under OCR standards now that they're incorporating these, but we'll explain kind of as we go what those standards look like.
Yeah, Jackie, and even more practically, I think if someone really asked you to explain, like in one sentence, kind of what these thousands of pages of new regulations actually mean for your institution, here's kind of what I'd say. You know, by August 14th, our institution must implement and train relevant staff on extremely detailed, thorough Title IX regulations that are heavily focused on principles of fairness and include just a staggering number of details, such as new definitions of key terms, specific procedures for handling complaints, notice and record keeping requirements, and training mandates.
Yeah. And we know that some organizations have already threatened lawsuits against the Department of Education. And in doing so, they almost certainly will seek to delay the implementation of the rule. But at this time, schools need to plan and prepare and move forward with preparing for this rule to go into place in August.
Yeah, I found really interesting that the head of OCR, Assistant Secretary Kenneth Marcus, had said on the record that the August 14th date was an unusually long period of time for compliance with the rule. And that may be true, but right now, wide swaths of the country are completely shut down because of COVID-19. And since the shutdown, I've actually received a number of new OCR matters where OCR hasn't even made a data request to us out of recognition that schools are really facing a lot of challenges right now with just continuing their operations. So it's a bit strange that the same agency would consider 3 months an appropriate amount of time for, in some schools, it's going to be a pretty big wholesale reconfiguration of their social misconduct policies and procedures and practices. But that's the timeline that we've been given, so we obviously are going to have to work with it.
So now that we've discussed some of our high-level thoughts, let's get into some of the specifics. So one thing to note is that the regulations use the terms complainant and respondent to describe the parties in a sexual misconduct dispute at a school. So we know many institutions have been moving away from this language recently and using terms like reporting party or responding party. But the use of these terms is notable because it may signal that the Department of Ed is going to be looking for institutions to use these terms in their policies and procedures moving forward.
That's right. And I actually wanted to test OCR's offer. If any of you watched OCR's lengthy, somewhat boring video on our webinar on the new rules, they did offer at one point that if you had questions, you could send them to the Open Center by email. So I actually did send them what I thought was a pretty short and sweet and easy question as to whether or not you would be required to use these terms. And I have not received a response yet since I sent that on Wednesday. So no idea how useful that offer is going to actually be. But another interesting thing about the complainant technology is that, the complainant terminology is that OCR has made clear that any person can report sexual misconduct. However, the complainant is the person who actually is alleged to have been the victim of the sexual misconduct. They don't give a name for the person who's the third party reporter. And so we've just called them a reporter. But again, that's just something we made up. It's not from the rules themselves. But what's clear is that even if third party reports sexual harassment occurred, that party is really not envisioned in having a role in any ensuing investigation or other resolution of the report.
Also interesting, the department makes a point to note that where it uses terms like victim, survivor, and perpetrator to describe the rules and schools' obligations under them, that they are doing so under the assumption that a grievance process would have been completed that resulted in a determination of responsibility, where a respondent was found responsible for perpetrating sexual harassment against a complainant, and therefore, the department would then be referring to terms like victim, survivor, and perpetrator.
So digging in now to some of the main changes in the new rule, one of the highest profile changes is the definition of sexual harassment. So sexual harassment is defined as conduct based on sex, and then there's 3 types of conduct that can fall within the definition of sexual harassment. So the first is quid pro quo, which is when an employee of the recipient conditions the provision of aid, a benefit, or a service of the recipient on an individual's participation in unwelcome sexual conduct. The second we're going to refer to as hostile environment, and I'm going to dig into that a little bit more on the next slide. And then the third is a set of terms that were pulled from the Clery Act as amended by the Violence Against Women Act, which include sexual assault, dating violence, domestic violence, and stalking.
And, no doubt for higher ed institutions, you're already thinking this, but we did want to flag for higher education institutions that are already used to having to comply with certain requirements under VAWA, that when responding to such conduct as you're rolling out compliance with the new Title IX rules, you will need to continue to look to make sure you are complying with VAWA as well, along with any other applicable state laws with which your institution must comply. Now for K through 12 schools, which may never even have heard about or thought about VAWA, you are now required to use the terms from VAWA in your policy, even though you are not technically subject to it. Now, we know some of you already have some policies in effect to address some of these types of conduct. For instance, in Illinois, K through 12 schools are required to have policies on teen dating violence. So this may not be a completely new concept for you, but there is going to be a relatively steep learning curve here on the K through 12 side. You understandably may not know these VAWA definitions, but will need to become very familiar with them. While the rules expressly state that schools are not required, for example, to adopt a particular definition of consent with respect to sexual assault, because the term consent is relevant to the definition of sexual assault under VAWA, K through 12 schools will likely need to consider and determine how this term will be defined under its policies, something that higher education institutions already needed to have in their policies. So your legal counsel and state school board associations will no doubt be helpful resources for you to gain familiarity with these terms, and help determine what the exact definitions are that need to be in your policies for your institutions.
So before I mentioned hostile environment, we want to unpack that a little bit more here for you. And this is one of those places where OCR is now going to be using that modified Gebser-Davis standard that Jackie talked about to define when a hostile environment exists that is sufficient for a school to be required to respond.
Yeah, so this is interesting because some of this hasn't changed really at all. We knew in the proposed rule and now in the final rule, it wasn't proposed to change, for instance, that conduct need not be unwelcome to be sexual harassment. It still needs to be unwelcome. It still must be based on sex.
Right. But a school's program or activity in the US is a major change, which I think we're going to be talking about more in a second.
Yeah, and there's also language about a reasonable person standard. So it's unclear if that's really going to bring any real change. The 2001 guidance that OCR used had an objective and subjective standard from the perspective of a reasonable person to determine if conduct rose to the level of sexual harassment. And, we didn't see any indication that the objective and subjective analysis is really going to be going anywhere. So this may not end up being that big of a change in practicality.
And then on the other hand, the severe, pervasive, and objectively offensive language is a very important change. Instead of assessing whether conduct is severe or pervasive to rise to the level of sexual harassment under Title IX based on a hostile environment, conduct must be severe and pervasive and objectively offensive. So, for example, in one instance of the use of a highly offensive derogatory term based on sex, even if viewed as severe, may not rise to the level of harassment under Title IX if it is not alleged to have been pervasive. Now, while such conduct may violate schools' policies generally, and thus a school would still proceed with investigating and addressing the conduct if found to have occurred, for Title IX policies, the definition of sexual harassment is now much narrower.
Yeah, and this is why, we've always thought that you should be using a uniform grievance procedure policy, and now particularly for things that may fall outside of the strict definition of Title IX, I think that's even going to be more important for you all to consider. And I do think that this is why quid pro quo and those Cleary Big Four conduct categories were pulled out of this hostile environment definition, because essentially what the department is saying is, well, for those types of conduct, for if an employee engages in quid pro quo, or if you've got one of those Cleary Act incidents, you don't have to consider severe, pervasive, and objective. One incident can be sexual harassment under this new definition.
Yeah, it's also not really clear how the language about effective denial of a person's equal access to the school's education program and activity is going to play out either. So for these open questions, it's going to be really important to pay particular attention and talk with your legal counsel about how these terms are likely going to be interpreted by OCR and what should be in your policies and procedures related to these questions.
Right. And, you know, just to give you a flavor from OCR's discussion in the final draft of the final rule, they say that effective denial doesn't require complete denial, that you don't have to completely be out of school or off a team or have that impact. And they also say that, you know, they're not looking for notions of the perfect victim to be applicable here, that they recognize that people experience sexual assault differently and that they react to it differently. They also point out that this standard of effective denial, it's not totally new. It's from the Davis case. And so there it is defined as any situation where the sexual harassment so undermines and detracts from the victim's educational experience that the victim is effectively denied equal access to the institution's resources and opportunities. Still not that great of a definition, but it isn't entirely new.
So I mentioned before the program or activity in the US part of the definitions. Let's turn to that now. There's going to be a big question about this, what this means under Title IX. Does it mean study abroad programs are not covered by Title IX, spring break trips? You know, we aren't sure, but the language appears to exclude anything that occurs outside of the US and requires dismissal of a complaint under the Title IX procedures where there is not jurisdiction. So of course it is an extremely important caveat that just because we're saying Title IX may not apply does not mean that your institution does not have responsibility to respond to reports of conduct that occur in these spaces. Or that even if you don't have a responsibility, that you shouldn't choose to address other claims that might not fall under the new rules definition through similar policies and practices to Title IX. Again, the Title IX rules may only be your school's floor. Another federal law or state law may apply, for instance, to misconduct that occurs on a study abroad program. And you might have tort claims or other state law claims for K through 12 schools. For example, here in Illinois, the Illinois Human Rights Act requires schools to respond to severe or pervasive harassment. And Illinois bullying statutes use the severe or pervasive harassment definitions as well. But there are these new technical limitations on using Title IX per se to address misconduct, including misconduct internationally.
Right. And this definition also requires sexual harassment to have occurred in a program or activity of the school, which means that the institution has substantial control over both the context of the sexual harassment and the person accused. So these terms aren't defined anywhere in the regulations, but they do come from Davis and have been relatively fleshed out in federal case law over the years. The Davis case, for example, said that this standard was met with respect to harassment by a student against another student in the classroom during the school day. But this question is going to be more tricky when we think about different locations and perpetrators that are potentially involved.
Yeah, and one other thing to note is that the rules explicitly sweep under the programs and activities blanket buildings that are owned by an officially recognized organization. So really what we're mainly talking about here are fraternities and sororities. You will still have to go through the substantial control analysis for unofficial organizations, but for officially recognized organizations, their buildings will be considered within the scope automatically.
So kind of on that note, one of the big questions and concerns with this substantial control definition is, whether that definition is going to completely exclude online and off-campus conduct.
Right, and this really it's concerning, I think, particularly in the K-12 space. But what is the control over the context of the sexual harassment if it's completely offline, off campus, and off of your tools?
Yeah, I do think it's an easier question if it is on your systems, if it is, conduct that was engaged in using a school's device, or if during remote learning on a virtual platform. But it's going to be an interesting question that we will have to look into further.
So another big change in the regulations is the knowledge that triggers an institution's responsibility to respond to sexual harassment. The regs didn't change everything again. It's still going to be the same types of information that are going to trigger knowledge. So it's still going to be that a person becomes aware of sexual misconduct because they observe it, or that they become aware of it because someone reports it to them.
Right, but the person whose knowledge will be imputed to the institution has been changed here. Before, a school would be deemed to have sufficient knowledge if a person with the authority to institute corrective measures, a duty to report to such person, or any other person who a student reasonably believes was one of those two categories either knew or should have known about the conduct in question.
So now it is only the Title IX coordinator, school official with authority to institute corrective measures, and for K through 12 only all employees. So again, it's important to note that this is just the floor, the baseline requirement. So for higher ed institutions, you do have the discretion to decide who must report, who may report, and may only, with the student's consent, report sexual misconduct that is reported to them. So importantly, schools can still decide to require all employees to be considered officials with authority, as the department now refers to them. Although it's possible that you could get some pushback from employees on this, especially if no other applicable law applies. Again, for K through 12 institutions, it's all employees, but for a higher ed institution that wants, for example, coaches and athletic trainers to still be responsible for reporting sexual misconduct, you can require them to do so, but it is no longer required under Title IX.
Right, and you might get some pushback from people who used to be responsible employees and now they don't want to be officials with authority. So you may get some pushback from those groups of employees that you're trying to sweep in. For K-12 though, because it includes all employees, this really doesn't signify a very big change. It is challenging because you've still got the responsibility to train all of your staff, and particularly on all of these changes, because everyone is swept in. And this is broader than what was initially proposed. Initially, what was proposed is that it was going to be Title IX coordinator, school official with authority, and then teachers. But instead, what we ended up with is all K-12 employees.
So once an institution has knowledge of sexual harassment or an allegation thereof, it must respond. And now that response, the standard is that it must not be deliberately indifferent, meaning that it must not be clearly unreasonable in light of the known circumstances. So this replaces the old OCR requirement in guidance that a school takes steps that are reasonably calculated to stop sexual misconduct from reoccurring.
And note that there's two levels of response that are going to come into play here. So first, for all situations where the institution has knowledge of sexual harassment or an allegation of sexual harassment, the Title IX coordinator must contact the complainant to discuss supportive options and provide notice about how to file a formal complaint. Note though, as we talked about before, this contact isn't necessarily going to be with the person who reported the conduct, who we've been calling the reporter. This meeting is with the alleged victim. So of course, the Title IX coordinator may need to meet with the reporter to collect more information before this meeting occurs, but the meeting with the complainant is now a required step.
Yeah, so that first meeting, the meeting with the complainant with supportive measures, you're going to notify them how to file a formal complaint. That's the first step. The second type of response under these new regs is made only if a formal complaint is filed. And the regulations contain a significant amount of detail about specific steps that must be taken in that response. We are not going to delve into those here because it would take at least 30 minutes probably to do so. But we want to alert you that you need to be working with your legal counsel and, figuring out how you're going to implement these very specific steps that must be put into play. And then note that only the complainant, so the complainant, or if it's a minor, their parent, they're the only ones that can file a formal complaint anymore. The Title IX coordinator can also sign, that's what they use, is sign a formal complaint to initiate one, but they are not therefore rendered a complainant. They are just signing off to say, we're gonna do this even though the complainant doesn't wanna be involved. The third party reporter though is not gonna have the authority to file that formal complaint, thus initiating these specific grievance procedures that must be made in response.
So with respect to supportive measures, note that this term is a replacement for what we used to refer to as interim measures. And the department has made a number of changes to what supportive measures should look like. They do make clear that supportive measures apply to both complainants and respondents. And they also make clear that supportive measures cannot be punitive or disciplinary. So this is a really interesting question here then, because when we think about what supportive measures may typically look like, if the complainant and respondent are otherwise in the same class or have overlapping schedules, and someone's class schedule or route during campus needs to be moved, then it compels us to think, well, could there be a scenario in which a respondent's schedule is moved and that not be deemed punitive? And when we first look at it, we wonder, could there be this scenario? And how could that be? On the other hand, it does appear that through the comments that the department is anticipating that there could be scenarios in which it seems like these measures could be taken where they may not be viewed as non-punitive.
Yeah, I think that's a really good point, Amy. I do think after looking over some of the comments, it may be a little less scary than it seems at first glance. The comments do say things like changing a respondent's class schedule, housing, dining hall, those types of things may be permissible under certain circumstances, but removal from all of an activity or all of a class schedule, for example, suspension, removal, being kicked off an athletic team, can only be done through this emergency removal process.
Yeah.
Or after a decision has been made, I guess.
Right.
Yeah. And with that the provision allowing the removal of students on an emergency basis, this is a pretty narrow definition, it does look like, although it is available. The definition looks like it's that the student must present an imminent threat to the physical health or safety of any individual. And that looks narrow when you compare it to, for instance, Illinois law governing removals of students through suspensions in K through 12, which requires only that the student's continuing presence be a substantial threat or disruption. So we'll have to continue to look at this emergency exception more to see, how it really compares to our other laws that we have in place to allow for emergency removals in other settings.
Right. And I'll admit, I did not get through all of the 2,082 pages of the most recent draft before we got here, despite, I think pretty good efforts to try over Mother's Day weekend. But I did search for imminent threat, and I didn't see a lot of guidance there at all. So I think we're going to have to really figure out what that means and how, as Amy said, does it come into play with our suspension rights, particularly in K-12. The comments do make clear that an employee can still be removed on administrative leave pending an investigation. So thank goodness for those of us that do personnel. But you do have to obviously make sure that you're complying with any state law, with anything in your own policies, and then also with your collective bargaining agreements. And then the regulations also include a significant amount of information regarding what is required for a fair process. So either under constitutional due process for public schools or under fundamental fairness principles for private schools. And one of the big things is there's this new requirement that you have to share all information from the investigation with the parties before a final report is prepared and released. Our understanding of this from reading the text is that this is the actual documents and evidence that's collected. It's interview notes. Your summary is going to be in the report itself. So our understanding is that this means you need to make this all available to them. And we don't know, we haven't worked through yet questions like what can be redacted from it, if anything. And then what happens is that you have to give this to the parties and give them 10 days to respond before your report goes out. All that evidence then also has to be available physically if you have a live hearing in the hearing location. Then after you do the report, you have to share the report again with the parties. And then we'll talk on the next slide about kind of the live hearing versus not live hearing thing, because it's a little complicated. And then after your hearing or your hearing alternative, you're going to have a final decision and then an appeal. The final decision has to be by a different decision maker, and it's not going to be your Title IX coordinator in basically any circumstance. And then your appeal also has to be by another decision maker. And there are specific limitations as to what appeals are going to be offered for, essentially dismissals and then for certain types of limited attacks on the final decision. So this is, again, just a summary of due process, which has been such a huge part of this whole thing. So it's just a summary. The procedures are very detailed, so you're going to obviously need to work through those as you're implementing this all in practice. And then I mentioned that we were going to talk about the live hearing issue. So just to touch on that briefly here, it's required in all higher education cases going forward. And during that process, each party's advocate has to be given the opportunity to cross-examine the other party, which is obviously going to be a big deal for at least the institutions that haven't been doing it so far. If you're in K-12, the hearing is optional. We know that from the rules. There also is reference to the fact that there has to be written cross-examination allowed if you don't have a hearing. And we think that there's a fair reading of the rules that say even if you do allow a live hearing in K-12, that you're not going to be required to allow live cross. And I'll just say I'm probably going to need to be very convinced to at least not try that, because I just think live hearings with cross-examination between the parties in K-12 is going to be really challenging, particularly for young students.
So the new rules also expressly prohibit retaliation. And under the new rule, retaliation includes intimidation, threats, coercion, or discrimination, and that includes charges against an individual for code of conduct violations that don't involve sex discrimination or sexual harassment, but arise out of the same facts or circumstances as a report of sex discrimination or a formal complaint of sexual harassment for the purposes of interfering with any right or privilege secured by Title IX. Now, I know that was a huge mouthful, and you may be asking yourself whether this definition now precludes you from charging a student with a different code of conduct violation if the misconduct doesn't rise to the level of sexual harassment.
Yeah, I think this may be a tricky balance for schools.
Right. The comments to the regulations say, again, as Emily just told us, that it's only retaliation if it's done for the purpose of interfering with the rights of a person under Title IX. So I think there are circumstances where it's going to be pretty clear that that might be a problem. So for instance, if you are only charging under another part of the code of conduct because it would be easier than complying with the Title IX procedure, I think that's going to be problematic. And then also the commentary in the rules suggests that, if you're going to pursue someone for lying or giving a false statement, it's got to be based on something more than just the fact that they lost during the Title IX process. That alone isn't going to be enough to suggest that someone was lying, and that could be seen, I think, as retaliatory.
Yeah. So, given that it does appear that the department has sort of gone out of its way to say that schools can still apply other policies and procedures, we think there is a balance here that can and will be drawn, but again, something else, another area to keep considering further. So we want to switch gears now and spend the rest of our time with you giving a checklist of what should be on your mind in the coming days and weeks as you move forward with implementing these changes. So first, a key step is going to be to update your key stakeholders on these changes and what they mean for your institution, your boards of education and board of trustees, as well as your chief administrators. And you want to identify as well then the team of individuals whose input and sign off will be necessary to make the changes to your policies, procedures, and practices, and ensure that they are on deck and prepared for these changes to be coming. You may need to be thinking about summer board meetings for some of these policy changes as well. You'll also want to begin confirming, who your team of key players will be who will be implementing the grievance process. Confirming your Title IX coordinator and any deputy Title IX coordinators, your investigators, your decision makers, both, who's going to be making the determination, as well as who will be making any determinations on any appeals, as well as anyone assisting with the informal resolution process.
And once everybody is updated and in the know and you've got your team pulled together, you're going to have to go through the really challenging effort of figuring out what your approach is going to be. Are you going to, as Amy mentioned, are you going to just go with what the floor is, or are you going to more likely go a little bit above that floor and find a different ceiling above what's required here. Do keep in mind that a lot of that is going to be impacted by your state law, and also that anything that is going to impact the terms and conditions of employment, you're going to probably be dealing with collective bargaining if you're dealing with employees who are part of a bargaining unit. So you should keep that in mind. And we did get a question of our boards are in the process of updating student handbooks for next year. What do we do? And I do think, unfortunately, you are going to have to grapple with this stuff really quickly to figure out what you are going to change, if anything, in your handbooks next year. So please reach out to us if we can be any assistance with that.
Yeah. So, the new rules do require a number of notices that a school must give to the parties at various steps throughout the process. So we'll talk in a moment about what those all are, but we would recommend considering preparing form documents and templates for those notices. This will help you be prepared and organized and be in a better position to implement the required steps in the grievance process when a complaint is actually filed. You'll also need to prepare and provide required notifications and postings. So the rules explicitly require that notifications be made to various stakeholders of who the Title IX coordinator is and their contact information, the required non-discrimination notice, as well as, once revised, the school's grievance procedures and process, including how to report or file a complaint of sex discrimination or sexual harassment, as well as information on how the recipient will respond. Schools also have to post on their website and in any applicable handbooks and catalogs the Title IX coordinator and contact information, as well as the non-discrimination notice. And another requirement now is that once training is being completed, schools have to post on their websites all materials used to train Title IX coordinators, investigators, decision makers, including those deciding appeals and any person who facilitates an informal resolution process. So schools should work with their legal counsel on this requirement, when especially considering the requirement to discuss how to handle any copyrighted materials that may be part of your trainings.
So your next to do is going to be update your policies and procedures. And this is going to depend really heavily on what type of institution you are and how state law varies in your jurisdiction. So many of our higher education clients here in Illinois, for example, already have very thorough and in many cases already compliant policies and procedures. For instance, live hearings are nothing particularly new to those in the higher education space. But for some of our K-12 districts, and even those that do already have relatively thorough policies, there's just so many new requirements here that likely aren't going to be addressed in many K-12 policies. So one of the big changes for K-12 schools is they're now going to be dealing with very detailed policies and procedures for Title IX, possibly for the first time.
Right, and for K-12 schools, the nice thing is that if you have a school boards association in your state that puts out model policies, it's almost certain that they're going to be issuing something you can use. And we know, for instance, that the Illinois Association of School Boards is going to be updating its press policies for K-12 schools to address these changes. We understand that that is going to be coming in June, and it sounds like Amy and I are going to get to help with that. So, I think they'll probably be good. But you do, need to check with them to see when those are going to come out, because you may not be able to wait for those to come out before you start moving forward with doing things like getting people trained and figuring out what your processors are going to be like. And then also remember, because we're dealing with this floor and ceiling thing, there may be amendments and changes that you're going to need to do to even those model policies once they come out.
Yep. And then as Jackie said, your next step will be then to plan trainings for Title IX coordinators, investigators, and decision makers, again, including those who will be deciding appeals. And those trainings have to include particular components that the rules now require key individuals to be trained on. We always recommend that these ideally be done in person with live hypotheticals and opportunities to practice. Certainly in light of current stay-at-home orders in some states, we're offering virtual trainings that can still incorporate that in-person feel and allow participants to engage with the trainer, have questions answered, and work through, your own procedures. those officials with authority, which is that new term used instead of responsible employees, we want to make sure ideally that they are also trained, ideally before August 14th. For K through 12 schools, this would be all staff. So when they come in, for example, for their in-services before schools start, or however those in-services are provided to those teachers and to those staff, you should carve out time, even if it's just a half hour, to remind them of their continuing obligations and relevant changes that they should know under the new procedures and policies. So as a practical matter for K through 12, because the regs have narrowed the things that would need to be reported, if anything, you will likely be covered for some time, even if you're not able to hold that training by August 14th, if your staff has already been sufficiently trained for Title IX. But this should be something that is high on the priority list to do as soon as possible.
Yeah, and remember too that for K-12 schools, we know a lot of you use your boards of education for certain decision-making roles, such as appeals of a superintendent's decision to the board. Remember that because the training requirements, because of the new training requirements, if you plan to do this going forward, those board members who will be deciding cases or appeals are going to be needing this training as well.
Yeah, and even though there might be some leeway on the all staff, as Amy just mentioned, I think when it comes to your investigators, your decision makers, and your coordinators, you really need to move to get them trained on all of these procedural changes before the implementation date. And then Amy mentioned earlier the checklist, earlier on the checklist, the documents and templates that we feel you need to create. And we wanted to briefly give you a list of those that are on the one hand that are required, and that's what you are seeing here. And then also what is recommended. So if anybody's catching up on this later on the podcast, make sure you go to our website and find these slides so you can see what these requirements are. You guys have been so patient. So many of you are still on here. So we're not going to read through these, but just be aware that those are the ones that are required.
Yeah, so there's also, as Jackie mentioned, a number of written notices or documentations that we do recommend that your institution put in place. So we have those listed here as well. And even though those aren't specifically required by the rule, we really feel like they're going to be best practice to ensure that you can back up decisions that are governed by the rule.
And finally, we did want to note that there are some record-keeping requirements as well, where institutions do have to keep certain records for 7 years. These include keeping investigation files, and the rules require specific things be included in those files for those investigations that have been conducted and completed. And so, we recommend having some sort of a checklist for your institution to follow to ensure that all of the things that do need to be kept in that investigation file are in fact being kept in your record-keeping procedures. Also, a requirement is to maintain certain documentation that explains certain decisions that schools have made along the way through the grievance process. So again, creating some sort of template form for keeping that required information will help to ensure that you are complying with these new obligations.
All right, we have made it to the end of our presentation. Thank you all so much for sticking around. We will try to get to the questions we weren't able to answer in writing on the blog. And for the person who submitted the anonymous question about liability, I want to ask you to reach out to me and chat with me about your question a little more, because I really want us to write a blog post on it. And then just as we said, keep checking back to Title9Insights.com for more insights from us as we dig through this even more, and also for resources that we will be offering soon to assist you with coming into compliance with these new rules as painlessly as possible. So thank you again so much, and we look forward to seeing you next time. Until then, please take care.